You are ex-sarpanch.
Ex-sarpanch.
And what 92 says?
92 says that the amount is recoverable from
92 says that when the property of the panchayat are with the person.
No action under subsection 1, 2 or 3. Why such action should not be taken against him?
आपको कोई प्रॉपर्टी वापस करने को लिए नहीं कह रहे हैं, आपको कह रहे हैं कि आपने misappropriate किया.
That is distinct from the facts in my case, Lord. But Lord, my assumption here is that the amount has already been.
Right.
Now the order is trying to next to P4.
P4.
P4 page number 18. Facts in brief of the petitioner was elected as Sarpanch of Gram Panchayat in the year 2010. Thereafter which the complainant filed a PIL, which was disposed of his action to approach the authority. In consequence to that, he filed a complaint before the CEO.
Yes.
After which an inquiry was conducted. And by way of that inquiry, an extra P4, the combined show cause notice under section 89 and section 92 of the Gram Panchayat Adhiniyam 93 has been issued to her.
This is not under 89 and 92. This is under 40 and 92.
And there is no non-compliance of section 89 before giving a show cause under section 92 minor. An extra P4 if I am trying to read.
89 and 92 both are independent provisions.
Before giving a show cause under section 92, 89 opportunity of hearing has to be given to the petitioner winner.
Yes.
Hearing by an extra P4, a liability has been imposed on her that she has to deposit this amount without giving a reasonable opportunity of hearing to the petitioner. An extra P4 of the operative part being on page number 19, the last two paras.
Yes.
उप निर्माण कार्य की प्रशासकीय स्वीकृति जिला कलेक्टर रीवा द्वारा दिए जाने के निर्देश है, परंतु शासकीय निर्देशों के विपरीत प्रशासकीय स्वीकृति सरपंच श्रीमती आरती साहू एवं पूर्व सचिव श्रीमती संगीता शर्मा द्वारा जारी किया गया है, जो नियम एवं निर्देशों के विपरीत पाया गया है. बिना कार्य के परीक्षण किए वर्ग ऑडिट जनरेट करना, मास्टर जारी करना, भुगतान हेतु एफपीओ जारी करना हेतु पूर्व कार्यक्रम अधिकारी सुश्री ममता पुरस्ते एवं सहायक लेखाधिकारी राजेश तिवारी समान रूप से उत्तरदायी है. पद का दुरुपयोग करते हुए कार्रवाई की गई है, जिसके लिए दोषी पाए जाने की पुष्टि होती है. उपरोक्त विवरण से स्पष्ट है कि आपके द्वारा सरपंच पद का दुरुपयोग करते हुए क्रमांक 1, 2 एवं 3 में वर्णित पीसीसी रोग घटिया गुणवत्ता विहीन निर्माण कराया गया है, जिस पर कुल व्यय की गई राशि 10,70,575 में से आपसे समानुपातिक रूप से राशि ₹267,645 वसूली योग्य पाया गया है. तालिका 4, 5, 6 एवं 7 में वर्णित निर्माण कार्यों की प्रशासकीय स्वीकृति कलेक्टर जिला रीवा द्वारा जारी किया जाना था, परंतु पद का दुरुपयोग करते हुए सरपंच सचिव द्वारा प्रशासकीय स्वीकृत आदेश जारी किया गया है, जिसके लिए आपको दोषी पाए जाने की पुष्टि होती है. आपके द्वारा की गई उपरोक्त अनुमतियों के लिए मध्य प्रदेश पंचायत राज एवं ग्राम स्वराज अधिनियम 93 की धारा 40(2) के तहत 6 वर्ष के लिए निहित गोप्य कर दिया जाए एवं वसूली योग्य राशि 267,645 अधिनियम की धारा 92 के तहत आपसे भू राजस्व की बकाया की भांति वसूली की कार्रवाई की जाए. आज दिनांक 24/1/20 को समय 3 बजे जिला पंचायत रीवा में उपस्थित होकर वसूली योग्य राशि इस डीडी के माध्यम से जमा करें. अपना स्पष्टीकरण समक्ष प्रस्तुत करें. My intention is before giving me this and show cause notice, which details the amount I have to deposit, there was no reasonable opportunity of hearing given to me. I have attached a similar case, an order passed by the coordinate bench, page number 24. That's the final order therein.
Yes.
The facts were similar. By the instant petitioners challenging the action of the respondents, whereby they have issued a notice to the petitioner on 31/5/19, asking him to submit his reply as to why an amount of ₹320 be not recovered from him under the provision of section 92 of the Adhiniyam 93. Learned counsel for the petitioner assailing the said order mainly on the grounds that the authority has not followed the mandatory requirement and not issued any notice to the petitioner under section 89 of the Adhiniyam and directly imposed jump to the conclusion that an amount of ₹320 be recovered from him. Section 89 provides us under liability of fund etc. for loss misappropriation. Every punch member, office bearer, office or servant of panchayat for Gram Nirman Samiti or Gram Vikas Samiti or Committee of Gram Sabha shall be personally liable for loss, waste or misapplication of any money or other property of the panchayat to which he has been a party or which he has been caused by him of misconduct or gross neglect of his duties. The amount required for reimbursing such loss, waste, or misapplication shall be recovered by the prescribed authority, provided that no recovery shall be made under this section unless the person concerned has been given a reasonable opportunity of being heard. If the person concerned fails to pay the amount, such amount shall be recovered as arrears of land revenue. When the counsel for the petitioner further submits that on this point, this court in the case of 17 MPL 73 has held that the authority cannot proceed on section 92 of the Adhiniyam unless the requirement of section 89 is fulfilled. Apparently, there is no notice issued by the authority under section 89, and that indicates the petitioner has not been afforded an opportunity to submit reply to the irregularity alleged to have been committed by the petitioner. Therefore, determination under section 92 by the authority is not proper. In view of the above, the impure notice is set aside. The authority is liberty to proceed in accordance with law.
Yes.
Now, this is clearly covered as the facts of my case. That's straight away section annexure 3-4. Section 92 show cause notice was issued to me without giving opportunity of filling of section 89. That is the requirement.
How do you say that 89 and 92 are connected?
No, section 89 is
There has to be a first notice under 89, then only an order under 92 can be.
Section 89 clearly states that if there is a misappropriation, there has to be an opportunity of hearing given to me to give my clarification as to why those irregularities that have come up,
Yes.
whether that is correct or not.
And what 92 says?
92 says that the amount is recoverable from me.
No. 92 says that when the property of the panchayat are with the person,
Section
then that person is called upon to return those properties. The moment those properties are returned, there is no question of issuance of any notice. So there is difference between 89 and 92. You read both, 89 and 92. Both are independent provision having no nexus with each other.
92 says power to recover records, articles and money. So
Yes.
the prescribed authority is of the opinion that any person has unauthorizedly in his custody any record, article or money belonging to the panchayat, but we are covered by third party law.
Read further.
Or Gram Nirman Samiti or Gram Vikas Samiti or Committee of Gram Sabha, he may be by a written order required that a record of article or money be delivered or paid forthwith to the panchayat or Gram Nirman Samiti or Gram Vikas Samiti or Committee of Gram Sabha in the presence of such officer as may be appointed by the prescribed authority. If any person fails or refuses to deliver the record or article or pay the money as directed under subsection 1, the prescribed authority may cause him to be apprehended and may send him to the warrant in such form.
So the moment that property is returned to the panchayat, the further action which are stipulated in 2, 3, 4, subsection 2, 3, 4 are not required.
Not, if I come to para number 4, Miller.
Yes.
No action under subsection 1, 2 or 3
Yes.
shall be taken unless a reasonable opportunity has been given to the person concerned to show cause why such action should not be taken against him.
If he doesn't return, then only show cause is required.
No action can be taken, Miller.
So he is called upon to return the property, money or any article under subsection 1. Suppose he returns that, there is no occasion to proceed further in accordance with subsection 2, 3 and 4. Now if you go to section 89, 89 does not speak about return of any property of the panchayat. That is a totally different, where the allegations of misconduct are. Now you read section 89.
89, liability of punch, etc. for loss, misappropriation.
Misappropriation. Now this is the first allegation of misappropriation.
Yes.
Therefore it requires a opportunity of hearing. It casts a stigma. So that is the basic difference between 89 and 92.
Right. Now, but in our case, there's an amount that we determined that they say we have misappropriated while.
So that for all purposes, that is a notice under section 89.
Along with
the provisions of section 92 has been misquoted. It should have been a notice under section 89, not 92. That has been clarified in one of the decisions.
Right.
They have misquoted it. Because if there are allegations of misappropriation, defalcation or embezzlement, that notice has to be 89 only, not 92.
No,
but the authority, they mention 92 always.
The show cause notice would say that this amount has been found as to be misappropriated by you. Hence, you have to come and clarify as to why this amount should not be recovered from you. But in this notice, they've said come and deposit the amount and say why no further proceedings should be taken against him. But to that part, I'm contesting, that for that a reasonable opportunity of hearing, principles of natural justice ought to have been followed.
So if there are allegations of misappropriation, the notice should be under 89 or 92. If there are allegations of misappropriation,
Okay.
that is the difficulty. Now, if notice against you is under section 92, आपको कोई प्रॉपर्टी वापस करने को लिए नहीं कह रहे हैं, आपको कह रहे हैं कि आपने मिसअप्रोप्रिएट किया, जो वर्क करें आपने कॉन्ट्रैक्ट. So that notice has to be under section 89 only, not 92.
In support of that, of my argument now, referring to another judgment of this tribunal, where exactly section 89 and 92 have been discussed, and para number 8 clearly discusses this, that if the amount is mentioned in the section, in the notice, though the wording is in section 89 and 92, that cannot be admitted to be a show cause of this. So I will refer to this judgment below.
Yes.
Para number 8 is a relevant part. To perusal of the extract quoted above, it is evident that the liability of the petitioner has already been determined, and the petitioner is being asked to deposit the amount and thereafter to file the reply up to the 6th date. The alleged notice 7 and 15 by no stretch of imagination can be called to be a show cause notice. In fact, it is an order directing the petitioner to deposit the amount first and then to submit the reply, failing which proceeding under section 92 of the Act shall be initiated against the petitioner.
Yes.
The impugned action is being taken in flagrant violation of principles of natural justice. The impugned communication that is show cause notice 7 and 15 does not fulfill the requirement of a valid notice in as much as it does not contain the particulars of the grounds on which the proposed action is sought to be taken. Admitted to the report prepared by the CEO on which show cause notice is founded has also not been supplied to the petitioner.
Yes.
That's distinct from the facts in my case. But my assumption here is that the amount has already been quoted, that we have to deposit this amount. Before quoting that amount, an opportunity of hearing ought to have been granted to us.
Yes. बताइए.
We have filed our reply. In paragraph 5, we have said that in the year 2015, one Kund Bihari Tiwari, resident of village Rampur, Naigari, district Rewa, filed a PIL wherein so in respect of the alleged misappropriation of funds and corruption being caused by the petitioner and the Panchayat Secretary of Gram Panchayat Rampur. The PIL was disposed of wide order, so directing him to approach the CEO Jila Panchayat Rewa. Then, Lordship, in para number 6, we have contended that in compliance of the above direction, the complainant filed the complaint before the CEO Jila Panchayat Rewa dated so subsequently in the year 2018, the complainant Kund Bihari Tiwari again filed WP trying to expedite the process of pending inquiry against the petitioner in relation to alleged misappropriation of funds and corruption. The aforesaid petition got disposed of by order takes so and so. Directing the director then Hikayat Nivaran proposed Madhya Pradesh to complete the inquiry within period of 6 months. Accordingly, in relation to the above so-called notice dated 6 February 20,
आप ये बताइए P4 89 में है कि 92 में? लिखा आपने 92, लेकिन 92 है कि 89 है? ये इम्प्यून नोटिस है.
there it is. मध्य प्रदेश पंचायत एवं ग्राम स्वराज अधिनियम 93 की धारा 40 सबसेक्शन 2 एवं धारा 92 के तहत कारण बताओ सूचना पत्र. Section 92 it actually said power to records articles and money, where the prescribed authority is of the opinion that any person has an authorization unauthorizedly in his custody any record or article or money belonging to the panchayat or Gram Nirman Samiti and Gram Vikas Samiti or community of Gram Sabha, he may by a written order require that the record of articles or money be delivered or paid forthwith to the panchayat or Gram Nirman Samiti and Gram Vikas Samiti or committee of Gram Sabha. In the presence of such officer as may be appointed by the prescribed authority in this bill. If any person fails or refuses to deliver the record or article or pay the money as directed under subsection 1, the prescribed authority may cause him to be apprehended and may send him with a warrant in such form as will be prescribed.
Yeah, that's all.
So, in our reply, we have also annexed a similar order passed by the Honorable Court Judge R1.
Yes. Yes, which page?
Okay, page number 7. Page number 7.
कौन सा relevant paragraph कहाँ?
Page number 9 of paragraph 3. The constitution of present administrative committee is in exercise of an administrative order deriving powers of section so and so. Clearly provide that on dissolution of Gram Panchayat, all the office bearers shall vacate and
ये तो relevant ही नहीं. ये तो इससे कहीं relevant ही नहीं. You have come against only show cause. You did not file any reply to show cause.
Thereafter, the recovery proceedings initiated were initiated against us to the appropriate honorable court.
Undisputedly, you have not filed any reply to P4. You are ex-sarpanch.
No?
You are ex-sarpanch.
Ex-sarpanch. During this period, we were in Sarpanch 2010 when this info issued by ex-sarpanch.
Let me challenge in this petition to show cause. Notice dated 6/2/2020 contained in P4. Next paragraph, the counsel for the petitioner contend that the petitioner is ex-sarpanch of Gram Panchayat Rampur, Janpad Panchayat Nai Gali, district Rewa. It is contended by the counsel on account of allegation of misappropriation pertaining to the various work which were undertaken in terms of the directives of the Rozgar Guarantee Council. The petitioner has been issued a show cause dated 6/2/2020 which is contained in Annexure P4. It is contended by the council that the Annexure P4, as per the recital thereof, the same has been issued under section 40 within bracket 2 as well as section 92 of the Madhya Pradesh Panchayat Raj and Gram Swaraj Adhiniyam 1993. It is contended by the council that by the impugned order, the petitioner is being called upon to deposit a sum of rupees 267,645, which according to respondents, the petitioner has misappropriated. The council contend that as the petitioner is being directly called upon to deposit the amount, therefore, without awaiting the reply, without awaiting or reply of the petitioner, direct liability has been fastened against the petitioner, and accordingly, the show cause notice is unsustainable. It is also contention. It is further contended by the council that before issuing notice under section 92, the requirements as stipulated under section 89 of the Adhiniyam of 1993 are required to be adhered to, whereas in the present case, the respondents have not initiated any proceedings under section 89 and directly a notice under section 92 has been issued, and therefore, in view of the law laid down by this court in WP 2273 of 2020, Ranjan Chaudhary, as well as decision of this court in Roshan Nargave versus State 2017 Volume 3 MPLD 73. The impugned show cause deserves to be quashed. It is further contended by the council that by this contended by the impugned show cause notice is a composite one, and as much as the same has been issued under section 40 as well as 92 of the Adhiniyam of 1993. And comma as per section 40 comma there is threat to declare the petitioner disqualified for a period of six years from contesting any of the election of the panchayat, and comma by the same notice comma the petitioner has been called upon to deposit 267,645 rupees and simultaneously is being called upon to submit the reply. Okay, it is contended by the council that once the respondents have already decided that the petitioner has to deposit the said amount on the issuance of notice is an exercise in futility, and therefore, the adjudication has already been done, even without considering the proposed stand of the petitioner. Accordingly, submit that entry of the order of this court in Bhagwanda versus State WP 5772 of 2016, the same deserves to be quashed per contra. Counsel for the respondent submission that in pursuance of directives in the public interest litigation, the action in has been taken by the respondents, and as the petitioner was found guilty of the misappropriation of the amount, and as much as on account of the petitioner lapses, the various work under the Rozgar guarantee were they are hindered and causing loss to the public exchequer. It is contended by the council that the petitioner then was called upon to submit a reply in exercise of powers conferred under section 92 of the Adhiniyam of 1993, as well as was issued a notice under section 40 of the Adhiniyam of 1993. Council contend that there is no infirmity in the notice dated 6/2/2020 contained in annexure P4. Thus, no interference is required. A tribal commission perused the record. A perusal of the impugned show cause notice dated 6/2/2020 contained in P4 reflect that the same has been issued to the petitioner under section 40 within bracket 2 and section 92 of the Adhiniyam of 1992. In terms of section 40, the petitioner has been called upon to show cause as to why she been not disqualified for a period of 6 years from contesting any election of the panchayat. And by the said show cause notice, the petitioner has been called upon to deposit a sum of rupees 267,645 with the office of Jila Panchayat Rima. Stop. The last line of the show cause notice reflect that the petitioner has been called upon to submit her explanation to this notice dated 6/2/2020. The perusal of the show cause notice reflect that there are allegations against the petitioner regarding misappropriation of the funds of the Gram Panchayat. Therefore, this notice appears to be a notice under section 89 of the Adhiniyam and not section 92 of the Adhiniyam. Taking a stop. Section 89, of the Adhiniyam, section 89 as well as 92 of the Adhiniyam provides as under दोनों को quote कर देना. A perusal of both the statutory provisions reflect that both the provisions operate in altogether different way. So far as section 89 is concerned, the same only deals with the office bearer, employee, servant, etc. of the panchayat, whereas section 92 deals with any person. Okay. Moreover, section 89 pertains to the misappropriation and also the negligence on the part of the office bearer slash employee slash officers, etc. of the bench, whereas section 92, comma, the section 92, comma, operates in a field where the property, comma, slash article or money of the panchayat is in possession of any person unauthorized. ठीक है? The entire showcase notice contained in P4 does not reflect that there is allegation against the petitioner of keeping any property slash article or money of the panchayat in possession of the petitioner. On the contrary, comma, the allegations of misappropriations have been leveled against the petitioner, which is evident from perusal of the notice, and the said allegations have and the said misappropriation have caused loss to the public exchequer. Taken thus, comma, in the considered view of this court, comma, the notice appears to be a notice under section 89 of the Adhiniam of 1993. For invocation of provision under section 89 of Adhiniam 1993, comma, an opportunity of being heard is sine qua non in terms of the proviso contained in section 89 of the Adhiniam of 1993. In the present case, comma, as directly the petitioner has been called upon to deposit the amount of rupees, the amount which allegedly misappropriated by the petitioner to the tune of rupees 2,67645, comma, therefore the same is unsustainable in as much as, comma, there is no opportunity appearing to the petitioner in terms of section 89 of the Adhiniam of 1993. Full stop. The other issue which requires consideration as to whether a notice under section 40 of the Adhiniam could have been issued to the petitioner in as much as the petitioner is not a sitting sarpanch of the Gram Panchayat. On the contrary, the petitioner is an ex-sarpanch of the Gram Panchayat. Section provides for removal of a sarpanch from the post, whereas, as the petitioner is no more sarpanch of the Gram Panchayat, the notice under section 40 should have been issued to the petitioner. That is another aspect which needs to be considered by the authority before issuing such notice. नीचे कर देना, in view of the aforesaid, comma, the impugn notice dated 6/2/2020 contained in P4 stands quashed. The respondents are at liberty to proceed afresh against the petitioner in terms of section 89 and are also at liberty to consider as to whether any action under section 40 is required to be taken against the petitioner under section 93 and 40 of the Adhiniam. Accordingly, the petition stands allowed to the extent indicated therein. Next.